Welcome back and thank you for staying with KTN Prime. Now we want to dive into our conversation. Remember, the former Deputy President Rigathi Gachagua's impeachment hearing has been going on at the courts, and we've been seeing a lot of back and forth regarding some of the issues that are being tabled by the different parties from representing both the government and the former Deputy President. And we want to have this conversation with none other than my guest here in studio. We have Kevin Osido, Executive Director, County Governance Watch. As always, good evening. It's always good to have you.
And to you too, thank you very much.
And we also have Dr. Eric Komolo, who's an advocate and legal scholar who's joining us via Zoom. Good evening, Dr. I hope you can hear me clearly. It's good to have you with us. And we will start with you, Dr. I mean, a number of issues have been raised by both legal teams, and we expect that ruling tomorrow at 1 p.m. So let's talk about that particular issue, the issue of fair trial that has warranted what the legal minds of representing the former Deputy President are arguing that three-judge bench needs to be recused. So let's start with that. How key is the ruling on that particular issue of fair trial?
In my own assessment, I think they will recuse themselves tomorrow. I think that significant doubt has been raised in the minds of the public based on the issues that have been raised by councils. And to the extent that perception in public has been created that there could be bias, I think then because of public interest, it will make sense for the judges to recuse themselves. Recusal, normally there's a standard. There should be real or perceived bias. And I listened very extensively to what was being said about Judge Bremer. I mean, it is no secret for us in the profession that they have been close with the Senate Speaker, and obviously more direct about Judge Ogola and other things. So I think they will recuse themselves. What worries me is the status of the conservative orders that were issued by the courts last week, because some were meant to expire tonight. So I think as part of recusal, they may need to extend the conservative orders. But it should be noted to members of the public that recusal is a normal thing that happens in courts. It's only that this is a more charged case, and judges from time to time do accept to recuse themselves or decline, particularly when it could be used as a delaying tactic or it could be frivolous. But in this particular case, I think on a balance, I think they will recuse themselves in public interest. And that should not be seen as a delaying tactic. I think the Chief Justice will have opportunity to appoint new judges to hear the petitions in a more, remember there are very many, in a more coordinated and impartial manner, whether real or perceived.
So what happens if they don't?
Well, I think I will borrow from what Dr. Minwa said. This being a heavily politicized case, I don't think that any judge properly guided would refuse to recuse themselves, because the mere fact that the DP has some supporters who may then create chaos, particularly because there's already perception that the impeachment process was heavily politicized, was hurried. Whether that is true or not is a different thing. So I don't think the court wants to kind of carry that baggage, because it is not their baggage. This is eventually a political process that, depending on where you belong, has not gone very smoothly. And to that extent, I don't think our courts, which have been, by the way, the only institutions still perceived to be living up to the ideals of the 2010 Constitution, I don't think they want to assume that baggage. I also don't think Professor Kindiki will want to assume office in a rather shrouded manner, in a manner that does not look to be befitting the stature of a deputy president. And I certainly don't think the Chief Justice or her deputy, the Chief Registrar, will preside over swearing in, because by Constitution they are supposed to preside over. swearing in of a deputy president, where the courts are perceived to be not impartial. So on a balance, it makes a lot of sense that the recusal thing happens, and that these petitions are heard constructively and impartially and independently by another bench. I need to mention that the three judges are highly professional. Justice Mrima has given very outstanding judgments in the past. Justice Ogola, who is in the family division, is known for his faith and for his judgments and leadership. Remember, he's the principal judge, so basically the head of judges in the High Court. And I've known Dr. Frida Mugambi since 2003 when she was my lecturer in Moi University.
Okay.
I've always known her as a stable professional. So this has nothing to do with them. This has a lot to do with perception and circumstances of the case they find themselves in.
Okay, coming to you, Osido, as we know what Dr. has said, this is a very politicized case. So in such a case that we know it's a political process that has found itself in the courts, can justice still be skewed?
Thank you so much, Ashley. Given the manner in which we found ourselves here, there are possibilities that, depending on where you stand, that you could consider that there are certain levels of skewness towards finding justice. I remember that there's a very good reason as to why in Article 50 of the Constitution, Kenyans decided to have what is called right to a fair hearing. And this is largely based on a background that we have had in the past. And if you look at Article 50 of the Constitution, there are a number of provisions, particularly from two, that therefore outlays the rights of this accused person. So whether it is political or too much legal and the legalist that is being thrown out there, the desire of the Constitution is that this accused person finds justice, and that part of this access to justice indeed is right to a fair hearing. And so I believe that this is partly why we are seeing this very long debate and discussion within the High Court to be able to find a fair standing for both parties. And you realize that when all this began, there were concerns about time. And I remember that Dr. Amin were asking the parties, where are we rushing to? What is the issue? Where is the rush, or what is this rush? And so those, in my view, would be quite fundamental in terms of deciding what happens next. And remember that we're also setting up a precedent to how we basically engage as a people, and particularly as a political society. And so because this is happening for the first time, I believe that there would be very many issues that the court is also interested in setting up precedents and grounding the Constitution around the many questions that we find ourselves. So I believe that concerns about how this therefore will come to a close would that the judges would be very keen to consider it fit to provide very stable grounds for both parties to feel comfortable and confident, and that justice would therefore be seen to have been done, and that it would be done to the extent that both parties would be comfortable.
Okay. And what he's equally mentioned is that from his perspective, the deputy president designate would not want to assume office in a shrouded manner. But look at the issues that have been raised in courts. The first one being the issue of the IEBC. Let's start with that, because the government is pushing to have those conservatory orders lifted so that the swearing in can proceed. But Kenyans are asking, so who cleared him?
Yeah, those are concerns that really we must deal with as a people. And remember that Kenya is a democratic state, and is a democracy that, as you mentioned, IEBC, we all know the roles and responsibilities of IEBC, particularly when it comes to such high-level institutions like the presidency, so the president and his deputy. And so concerns around and about clearing of candidates against what is the expectation of the Constitution and indeed other supportive legislations like the IEBC Act, even the engagements with political parties. So we must be very clear around who cleared him, when he was cleared, when he ceased being a member of the political party, when he became a public officer, public servant, state officer. All those are concerns that I am sure that the discussions around the court will be seeking to deal with, because otherwise we will still continue to see as many petitions, because given the manner in which the conversations are going on, both parties are also seeking to fill in any gaps that might present chances of any concerns. And hence the reason, and I agree with Dr. that even the judiciary, particularly the Chief Justice and the Deputy and the Office of the Registrar, are also trying to distance themselves, particularly around the swearing in, because indeed it is that institution that will be seen to be taking the responsibility, as is expected by the Constitution, that the Registrar of the Judiciary really stands to the fore and undertakes the process of swearing in this new Deputy President. Therefore, I don't think that they would want to be clogged into a confused process, an exercise that really would also want to dent the judiciary. And as Dr. says, and I also agree, the judiciary really currently stands as that institution that Kenyans still consider to have a very high degree of public trust and confidence. And so it would be very important for them to also want to listen to the ground and weigh these political issues against the legal concerns which parties have, and therefore present a very sound ground that therefore makes Kenyans comfortable that the Constitution is being implemented and that justice is also being done.
Okay. Coming to you, Dr. Of course, picking up from where Osido has left, from a legal perspective, was it in order for an IEBC without commissioners to clear Professor Kithure Kindiki?
First, actually, I need to clarify something.
Okay.
From where the law stands, the Deputy President remains Rigathi Gachagua, to the extent that the resolution of the Senate was stopped. Implementation was stopped by the conservatory orders that have been issued. I've had people take sides, but the law is the law. There's a process for somebody to assume office of the Deputy President, and there's a process for somebody to leave that office. And to the extent that that process has not been concluded or has been stayed, then that person remains in office. The politics of whether he exercises administrative powers, that is beyond us for sure, because it is obvious that he doesn't have the instruments now and facilitation now to discharge the functions of that office, but he remains the Deputy President until the orders expire or are lifted, and until then Professor Kindiki is sworn in. Two, actually, we don't have a constitutional crisis in Kenya. We have a political crisis.
Okay.
And importantly, the political crisis is being used in a positive way, in my view, to test the Constitution, which provides process and stages for impeaching President and Deputy President. And the fact that everyone can predict where we are going, which court we are in, and next until it gets to Supreme Court is a good thing. So impeachment of Mr. Gachagua may obviously be causing a lot of fatigue. For obvious reasons, it has gone for too long. But it is simply the Constitution being followed, and the Constitution is working. Obviously, there are big questions about clearances that a candidate needs to have to be nominated as a deputy president, and therefore be processed, particularly the process of resignation, impeachment, or death. So there are clear questions that will have to be tested in court, whether, for example, Professor Kindiki is qualified to be a member of parliament. IEBC apparently has cleared him. Whether he is a member of a political party, that is the law and our Elections Act. What we know for sure is that state and public officers holding cabinet position, principal secretary position should not be members of political parties, or at least should not be the governing council of political parties. And there are several other requirements that he seems to have obtained that are questionable, to the extent that the elections law outlaw them when you are serving actively as a state officer, as a public officer, and it is true that he's still serving as Cabinet Secretary for Interior. Another logical question is whether those are significant provisions of the law, particularly because are we living in utopia that people that have stature of cabinet secretaries or even teachers, public officers, are not politically aligned? So was it necessary? What was the jurisprudential reason for having for that requirement that people should not be members of political parties, when we know for a fact that until he became CS, he was a senator for Tharaka Nithi, and obviously he had political leanings, and we all do one way or the other. So I think the court will have to look at all these issues, and somebody has actually petitioned on that, and test them, whether there are such significant requirements or they are just other, subsidiary requirements that were introduced perhaps to lock out other people. There are several laws in Kenya that are introduced discriminatorily to lock out other people based on politics of the moment. But look, that is why we have the courts. And that is why the courts should take time to decide all these issues being raised very impartially, very professionally, but also in a manner that everyone perceives to be independent, because that is really the argument I've seen in court the whole day. They were just going around, but the fact is they were creating perception of lack of independence in the bench as presently constituted, not their professionalism, perception of lack of independence. And I think that will be cleared one way or the other tomorrow, next week, and then we'll have to test all these issues that you've asked about.
Okay, Osido, coming to you, I mean, either way, this process is going to come to an end. It could go either way. Either Rigathi Gachagua could be reinstated as the deputy president, or they could, just give a go-ahead to the entire process. So let's take a look at the scenario where the courts decide to reinstate him. I mean, how is it untenable for him to go back to office? And how does this affect governance? Considering, I don't know if you saw his press statement after leaving Karen Hospital. Mm-hmm. Clearly, there are differences that cannot be reconciled. Yeah. How will that affect governance?
We must be deliberate to deal with the contextual issues as they arise. Mm. Because remember that some of these issues were not foreseen. However, even in as much as I consider them unforeseen, we have had some of these concerns tested, because this is not the first time we are having such high-level, high-octane conflicts and disagreements between a president and his deputy. President William Ruto, as deputy president, for almost 89% of his term with President Uhuru Kenyatta, were actually gobbled in a scenario like this. And how those issues were dealt with, I think, really should inform how some of the lessons that we learn. Of course, to take note of the fact that President, in the second term of their term of their tenure, we saw the president, the deputy president, coming out to be campaigning as president, and indeed he is now president. And even in so looking at what happened then, is to ask ourselves, must it be like that? So what are the lessons that we are learning even post the concerns that the deputy president raised as he left Karen Hospital? The beauty of this, actually, is that we have institutions. For example, that DCI would now be very, very interested in some of the issues that were raised by the deputy president. And we, of course, have seen some invitation that was sent to the deputy president to appear to record a statement. He has not been able to do that. And we are looking forward to seeing how, indeed, those institutions will be able to present an opportunity for some of those concerns to be dealt with. The core concern should be the question that you asked. So how will he work with his boss? Remember that even at the National Assembly and also at the Senate, he provided or presented some very interesting videos of his boss. And he kept saying, this I learned from my boss. And when you see me doing a good job, I've learned from my boss. A bad job, I've learned from the best. So it therefore goes back to asking the question around the presidency. What kind of precedent have we set for the president and his deputy to work? And part of this really boils down to responsibilities and roles of the president, which are very clearly stated in the Constitution. And when it comes to the deputy president, it says shall be the principal assistant to the president. And President William Ruto, in my view, did very well to exercise his piece of wisdom and provided certain responsibilities through an executive order to his deputy. Now, actually, interestingly, none of those allegations that were raised by the petitioner, the motion mover of impeachment, really boiled down to the executive order in terms of the responsibilities of the deputy president. So therefore, we can say that we should not see as much of a conflict and antagonism between the president and his deputy based on functionality concerns, because we would therefore say that given that those 11 allegations, almost none of them touched on the workings of the deputy president, Mheshimiwa Rigathi Gachagua, as opposed to either corruption or incitement and many, many other issues that were raised. And of course, the Senate summarized or arrived at about 5 grounds of impeachment, which therefore they were asked to approve. But therefore the concern is, would it be okay that the president and his deputy can work based on that executive order in confidence to serve the people? I think that also is a very high political question, because therefore you ask yourself, yes, of course, there is executive order, but how does the context of executing these responsibilities look like? And I think that for me, in finishing this matter, Kenya Kwanza has not done very well to do certain ground laying and ground setting for a new government, or when, of course, we transit from elections, then there are basic things, for example, induction sessions and workshops. And during the campaigns, we thought that there was a very good gel between Kenya Kwanza political leaders, especially the president and his deputy. And we saw them working very closely. Now, we don't know what really happened, that this rift has really widened and grown so big that it gets to a level of an impeachment, and the president is so silent. So I think that we need to begin to look at certain governance and leadership principles, and one of those is very easy things: effective communication, gelling, induction processes, retreats for leaders, because these are people who probably did not know each other. And you are like a husband and a wife, a girlfriend and a boyfriend, people who want to get into a union. And I think that the political party also should have done much more better to help ground the institution of the presidency, not in terms of the roles and responsibilities, because again, Kenya Kwanza has not done very well to be able to deliver on many, many promises which they gave to the people. So this must not be the political question that is going to divide them.
Okay. Dr. Ari, coming to you even as we close, you talked about the issue of conservatory orders, and I believe tomorrow the 3-judge bench is going to rule on it. So let's talk about the fact that there are 2, or I understand we have lost Dr. Eric Komolo, an advocate and legal scholar. Coming to you, Osido, even as we conclude, let's talk about how fast this process has been. And this is something that has been in Kenyans' minds, and people are actually talking about it. This means that the government can actually work to satisfaction if need be. What are some of the lessons that we're learning from this impeachment? Because if you look at what the reports were saying, for the first time, we're seeing the House is full, both Senate and National Assembly, just to hear this particular issue. And on the other times, there are people who have been told to have appeared once or twice in Parliament. I mean...
one of the lessons is that Kenyans, we are on our own. That's really one of those very key observations. Of course it is, but what do we do? Because from Madani to Chief, and all these things are happening, and at the same time, we have this very high level interesting concern about an impeachment process, which if you talk to many, many Kenyans, is really not a priority. And I think that their voices counted during the public participation process. And if you look at, as you rightfully said, Ashley, the quorum concerns during this process were not an issue. And at the Senate, for example, the following day, when they had a toll of many, many other things in the order paper, they basically went off because they didn't meet the quorum. It basically means that the priorities of the political class and those of the citizens are like east, as far as the east is from the west, the moon and the sun, day and night. And that really should inform, again, the third thing, which is how we vote. Of course, this is not very grounding, But I believe that it really shows us, as the electorate and the people, the voters, the kind of leaders that we vote for. And some of these people in Parliament, both National Assembly and the Senate, were voted into office because they were, one, maybe part of the best within the cream that was there, and two, people had a lot of confidence and trust that, yes, of course, I'm saying this ceteris paribus, the Supreme Court and many other petitions that were there at the High Court based on concerns that people had in 2022 elections. But of course, it goes back to asking ourselves, have we done enough to present the right people to be voted into office? And then the fourth thing, of course, actually is a kind of precedence again that we are setting, that now we are getting to even have agreements around what would lead into possible grounds. So what are these grounds for a possible impeachment?
Okay, I want to have the last word from Daktari. I hope you can hear me now. Even as you give your final remarks in 1 minute, just talk about the conservatory orders. As you'd mentioned earlier on, you're looking forward to that ruling. But of course, there are two. There was one in Nairobi and another one in Kerugoya. One has a time limit of 24th, which is today, and one did not. How does one affect the other?
If it is true that the one by Justice Chacha Mwita did not have time span for lapsing, then I think the petitioner is safe. It will lapse when the court makes a contrary decision, which is to lift it. In effect, it simply means, and by the way, I think that could be the true position, because the three judgment could not have just left to today without extending the order, because they know the consequences and the perception it will have on the judiciary. But the net effect is that we will not have Professor Kindiki proceed to be sworn in until the petitions are heard and determined, or the orders are lifted. But look, earlier Mr. Osido was talking about the dynamics of the president and the deputy. I agree with him, but I just need to add that I don't think that the president and his deputy need to be friends. It is good for the country if they agree on every policy agenda, but they don't have to be friends. The Constitution stipulates their roles, and that is what needs to be implemented. If there's a disagreement, then the person with the ultimate responsibility is the president. The country still has to continue. But remember also that Kenya is not the only country where the deputy president and the president have disagreed. It has happened. It happens a lot, by the way, in Malawi, and it has happened in several other jurisdictions. What is important is that the Constitution envisages this situation of running mate for purposes of continuity. And if it's not working, then the Constitution itself presupposes, outlines a procedure for replacement, which is what we are going through. And that same Constitution gives the person to be replaced rights, which is also what Mr. Gachagua is defending. So the long and short of it, there is no constitutional crisis. It is political crisis, which is also good. And the Constitution is working. And from where I stand, I'm very happy that we are testing the Constitution the right way.
All right, thank you. That's a really good place to end this conversation. Thank you, gentlemen. Dr. Eric Komolo, advocate and legal scholar, joining us via Zoom. And of course, with me here is Kevin Osido, an executive director of the County Governance Watch. That's how we wrap things up. Thank you so much for joining us and trusting KT News to inform you.